Welcome to our webinar today on homelessness and special education. We're very pleased to have you with us. We realize it's a very busy time of year, as always. So we're grateful for your time in sharing the next hour or so with us on this topic that we've received a lot of questions on and a lot of requests for a webinar. So we're always happy to try to meet your needs. And if you ask us for something, we're going to try to do it. So hopefully this webinar will be helpful for you. In the chat box, you can see that my colleague Karen Rice has inserted the link for this presentation, so please feel free to click on that. You can access it right now if you'd like to. If you're not familiar with Schoolhouse Connection, we are a national nonprofit organization working to overcome homelessness through education. I am Patricia Julianell. I am the Director of Program Advancement and Legal Affairs at Schoolhouse Connection. Karen, I didn't alert you to this, but if I can put you on the spot for a second, do you want to introduce yourself?
Absolutely. I apologize. I can't share my video. It's not working, but it's wonderful to be with you all today. I'm Karen Rice. I am the Senior Program Manager of Education Initiatives at Schoolhouse.
Thanks, Karen. Karen is going to be monitoring your questions today and providing some additional information. So I'm really glad she's here with us. I assume you're all familiar with Schoolhouse Connection since you're on the webinar, but one thing that I would want to point out to you is the Q&A from our inbox feature. On our website, if you go under the tab for Learn, you will see access to Q&A from our inbox. These are actual real questions that we have received from people like you. We depersonalize the information and post those on the internet, and we have a lot of Q&As about special education in particular, in addition to many other topics. So just as a follow-up to this webinar, I would invite you to hop into the Q&A from our inbox, and you can take a look at all of our questions and answers. They are categorized by topic, but you might specifically want to look at those special ed Q&As. So I wanted to make sure you're aware that that resource is available. The other thing we wanted to make sure you are aware of, because it is going to be a new resource from us, we are about to launch online modules for school staff. So these are very short trainings where different roles in your school or school district or charter school, from teachers to health staff to counselors to school resource officers, administration, transportation, etc. Those different individuals can access online modules that are specifically designed for them. As well as some general McKinney-Vento 101 modules. We're looking to launch those in the first quarter of next year. So you can go on our website there on the SHC training modules page and get more information about exactly what those modules include, what the pricing will look like, and when we hope that they will be available for you. But we wanted to let you know that those are coming. Again, I'll just mention for anybody who jumped on recently, Karen has put the link for the PowerPoint in the chat. We're going to start off today by doing a quick poll with you. We're going to use Mentimeter. So I think Karen's going to pop that link in the chat. Also, you can also just go to menti.com and use the code that you see on your screen there, 51540897. And again, you can take a look at the chat box for the link to the menti.com poll. But I am going to exit out of my PowerPoint for a second and share the actual Menti with you. So again, yeah.
Can I interrupt you real quick? I'm sorry. I am not able to post in the chat. A couple of people have commented in the Q&A box that the chat is disabled for everyone to view.
Yeah, I don't know how to fix that on the webinar. I thought that everybody could see the chat, but let me see if there's a way that I can fix that. Here we go. I just put everyone. So hopefully now that should work for everyone to see the slides. And now I'm going to try to post that Mentimeter link for everyone. Hopefully that you are able to access that now. Oh, and I just did something that I didn't want to do. Okay. So hopefully you're able to access that Mentimeter right now. I see some people are typing in information, so some people are accessing it. So that's good to see. So if you can click on the link in the chat, you should be able to see that Menti link in the chat. If you can't see the Menti link in the chat, let me pull up my PowerPoint again. You can just go to menti.com and you can type in this code number, 51540897. So hopefully one of those will work for you fairly easily. I do see lots of answers coming in, so let me show you that. Hang on a second. We have to share a separate screen now. This is all very exciting to do these screen sharing. Here we go. Now you can see the information coming in. I'm interested in knowing, what specific questions you might have. If there's one particular special education issue that's really been bugging you and that you've been having a lot of questions with or about, you can type that in. I like this sort of knowledge, power, passion. Those are some pretty cool issues that hopefully we'll definitely be able to give you knowledge. I think we will be able to give you some passion, satisfy your curiosity. You'll definitely have some information that will help you collaborate with your special education partners by the end of this. So hopefully that'll be helpful. Legal implications. We are actually going to provide you with legal citations. So hopefully that's going to satisfy that need there. I see people looking for understanding, support. Hopefully the information you gain here will provide you with some support for advocating for your special education students who also are experiencing homelessness. So this is great. I always love the word cloud because it just gives us the opportunity to see sort of what's on your mind. I see out of district placements. We are going to talk about that in particular. So hopefully we're going to meet most of these needs that I see here on the slide. Youth, we will be talking about unaccompanied youth as well. So this is great. I really appreciate you taking the time to pop into my Menti and your patience with our chat box snafu. So I'm going to go back to the PowerPoint now. Here we go. And let's just jump into the information. It's great to know what you're here for. I'm going to try to satisfy all of those needs and also provide plenty of time for question and answer as well. So here's our general agenda. Like I said, we are going to talk about unaccompanied youth. We're going to talk about some issues around timeliness of enrollment and evaluations and services. We're going to talk about transportation and costs. I know that that's a question that comes up a lot, and we will be providing specific legal information. So hopefully this is going to be very useful to you. One thing I want you to keep in mind throughout the presentation, there's a lot of, I would say, imagined conflict sometimes between the McKinney-Vento Act and IDEA, or the Individuals with Disabilities Education Act, where people might think, well, we can't do this McKinney-Vento thing because we have to do this IDEA thing, and they don't agree with each other. So one thing to keep in mind is that actually under the IDEA, school districts and charter schools are required to comply with McKinney-Vento. So these two laws actually are really working completely hand in hand and not conflicting. So there is a specific provision in IDEA that says that any state receiving IDEA funds, which is every state, must comply with the McKinney-Vento Act for all children with disabilities who are homeless. So actually, if you're working with a McKinney-Vento student who has a disability, who has an IEP, who is receiving special education and related services, if you're not complying with McKinney-Vento for that student, you're not complying with IDEA for that student. So this is something important to keep in mind and to be aware of, and maybe to share with colleagues, that we really do have to be in dialogue and in collaboration about these two laws, because legally they are required to work together. So that students who need services under both these laws get those services under both of these laws. So just keep that piece in mind kind of as a foundation as we go through some of the more specific issues. So the first thing I want to talk about, and we're going to do this through scenarios, is that question of decision-making for unaccompanied youth. So here's a scenario. An unaccompanied youth who is receiving special education services is residing with her grandmother. She has no communication at all with her parents. I want to make sure we're following parental rights as outlined in McKinney-Vento, as well as the IDEA. This is an actual question that we received from a school district. So who can make special education decisions for the student? The parent, the grandmother, the student, somebody at school? Who can do this? Well, there are a lot of answers to this question, so let's go through this step by step. The word parent has a definition under IDEA that is very specific and probably different than other definitions of parent that you're familiar with. And I put the definition on the slide, and it's numbered 1, 2, and 3 for a reason. The most powerful decision maker, the person that you always need to go to first, is the parent. I use the word natural and adoptive parent here because that is actually the language from the law. So we're just talking about these child's parents, whoever they may be. They're always going to be first priority for decision making. So in the scenario of this youth who's living with her grandmother and she doesn't have any contact with her parents are still the primary decision maker under the IDEA. So that's where you have to start. You have to send some, a letter home, quote unquote, home to the parents. You might not even know where that home is, but you do your best. You might send them an email. If you have an email address, you might make a phone call if you have a phone number. However, you can try to reach that parent. That's really where you have to start under the IDEA. So that's always going to be number one. And you want to keep track of those contacts that you're trying to make. So you want to, and this probably isn't you, if you're a McKinney-Vento liaison, this would probably be your special education team who would be doing this. So they're going to want to have some kind of a log where they say, on this day, we sent an email to this email address. On this day, we made a phone call to this number, documenting those efforts to reach the parent or legal guardian. Now, number two, you make a couple phone calls, you send a couple emails, you're not hearing anything back. So then you can go to number two. And number two is an individual acting in the place of a parent with whom the child lives. So you'll see this says including a grandparent, step-parent, or other relative. Including is actually specifically defined in IDEA as including but not limited to. So in our scenario, we have a youth who is living with her grandmother. So grandparent is specifically on this list. That's pretty clear. The grandparent is acting in the place of a parent, and the child is living with the parent, with the grandparent. So it's pretty clear here that if you can't get to number one, number two is actually going to meet the definition of parent. So the grandparent is really just going to step right into the shoes of the parent. You don't really need to do anything additional or special. You can just have the grandparent be in charge of decisions for special education. Now, if this were not a grandparent, if this were, the parent of a friend or some other individual who maybe the student is not related to, if the student is living with that person is acting in the place of a parent, then that person also can be number two. It doesn't have to be a relative, because remember, including is defined as including but not limited to. So it includes a grandparent, step-parent, or other relative, but it's not limited to them. It could be any individual acting in the place of a parent with whom the child lives. So in this case, your school district makes a couple of calls, you can't find the parent, you send a letter, you send an email, parent's not responsive, you go to number two, and the grandparent's just going to step in and be able to act for special education for that student. Now, if we were in a situation where this child was not living with a grandparent, or they were not living with any individual who was acting in the place of a parent, then the school district or the charter school would have to appoint a surrogate parent. A surrogate parent, usually the way it works is the district or the county or even the state has kind of a pool of individuals who are trained to be surrogate parents, and they get appointed almost like an educational guardian, but they're really specifically for special education only. And usually, there's a system that's in place for that. You would follow the same system for a McKinney-Vento student as you would follow for any other student. The difference with your unaccompanied youth is that there's a specific provision in IDEA that provides for temporary surrogate parents. So what does that even mean? Well, sometimes a surrogate parent can take some time to appoint. It's supposed to be usually around 30 days, but I've certainly worked in states and districts where it can take longer than 30 days to appoint a surrogate parent. And you might have an unaccompanied youth who's been moving around a lot. They've just gotten to your district. Maybe they have an IEP from a previous district, but it's expired, and they just need really a quick meeting just to update a couple of dates and have somebody sign it. And you want to get those services in place right away for that student. You don't want to have to wait for the surrogate parent to be appointed. That's when you can use somebody called a temporary surrogate parent. That temporary surrogate parent can be anyone. It can actually be the liaison. It can be somebody who's, an informal caregiver for the student. It can be a person from a shelter where the student might be living. That temporary surrogate really can be anybody. You want it to be someone appropriate who knows the youth, but it can be anyone who can go ahead and in a very quick way, sign an IEP, sign a consent to get evaluation started. So again, you're not waiting 30 or 45 days to start evaluations to get that surrogate parent appointed. You can just go ahead and start them very quickly with the temporary surrogate. And then you're still going to go through the process to get a regular surrogate parent appointed. Sorry, the temporary surrogate doesn't take the place of the surrogate parent. It's really just a stopgap to get things moving while you are working on getting the permanent surrogate parent appointed. So you've got these 3 layers of parents. You're going to start with number 1, go to number 2, and end up at number 3 if necessary. And that's really the way it works under IDEA for unaccompanied youth. You've got a link at the bottom of this slide which explains these rules in much more detail and really goes through some of the sticky and tricky questions. I'd really encourage you to take a look at that. I think it's a really good publication. It's something that I worked on with the National Association of State Directors for Special Education. So we have a lot of special education expertise in that document. And I think it's something that'd be really helpful if you have questions about decision-making for unaccompanied youth. Now, one thing I want to mention, if you have a lot of experience working with unaccompanied youth under the McKinney-Vento Act, don't be confused. These are who makes decisions for special education purposes for unaccompanied youth. For everything else that's not special education, you're going to look at the McKinney-Vento Act, which very clearly states that charter schools and school districts are required to give priority to the wishes of unaccompanied youth. So basically, unaccompanied youth are making their own decisions. That is going to be true for really everything: school, classes, school attendance, extracurricular activities. The only thing it's not going to work for is special education, because we have this special law, IDEA, that makes some particular provisions for decision making for special education. It's also a little different under FERPA, but we're not talking about FERPA today, so I'm not going to get into that. So you actually can have a youth who's making all their own decisions for lots of other things related to their education, but when it comes to signing an IEP or consenting for special education evaluations, that's when you need to look at this slide and you need to go through this process, because IDEA actually does not give any rights to youth. IDEA only gives rights to parents under this sort of 3-tiered definition of parent that you can see on the slide. So hopefully that didn't just confuse matters more. Again, I encourage you to take a look at that document if you really want to dig into this unaccompanied youth issue. But let's continue the conversation with just one other scenario. Now, this is a scenario where the parents are involved. And again, this is a real question that we received from a school district. An unaccompanied youth who is not in agreement with his parents about his IEP. He's currently living in a youth shelter until he turns 18. The student is working hard to advocate for himself, and the parents are creating many barriers to his education. And I could go into more detail about what this person described to us about the student really trying to come to school, really being serious about his education, and the parents putting up a number of different barriers in different ways, including fighting about services in the student's IEP. So the question was, can my student have another adult to be identified as the signer of the IEP, and do his parents retain the rights to sign the IEP? So this is a very different scenario than the first scenario that we saw, but the answer is going to follow the same 1, 2, 3 process. If the parent is actively trying to be involved in this IEP and in this special education process, then they're the ones with the decision-making power. We can't go to number 2 or to number 3 if number 1 is present and is available and is making these decisions. So there's really not a place, unfortunately, for the youth to make his own decisions. There's not a place for the youth to say, I don't want my parent to be the decision maker. I want this other person to be the decision maker. The parent really is going to be in charge here, because again, like I said, IDEA provides rights to parents, not to students. So the parent really is going to be the one who's kind of in charge of this IEP process. Unfortunately, they're using it sounds like they're using it as a way to maybe punish their child or manipulate or do other things, but legally they do have the rights. So the student cannot have another adult identified as the signer. The parents do retain the right to sign the IEP. So what are the school's options in a situation like this? The question we received, the school really wanted to provide the services that the youth wanted, because they really wanted to support his attendance and success in school, but they were kind of stuck by the parents saying, no, 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 no. So what can you do? Well, under IDEA, a school district actually can have a dispute with a parent about what needs to be on an IEP. That's a different process that we're not going to go into right now, but there are some specific dispute resolution policies in IDEA, and that might be something a school could look into. But I would say before going that route, one thing the school could do is get creative about what is it that the youth needs and what is it that the youth wants, and can those services be provided outside of an IEP? If the youth wants to see a counselor, let's say, and they're a mental health professional, and they have that on their IEP as a related service, maybe they have group counseling once a week, maybe they have individual counseling once a week on their IEP, and the parents saying, no, we don't want that. Okay, that's fine. You can take it off the IEP if that's what the parent is saying. But what about other mental health resources that are available in the school that you could connect the youth with that aren't even included in an IEP that lots of students would access regardless of having special education needs? There might be other things like tutoring or academic support that's available in the school, again, without having to go through the IEP process. So what I suggested to this particular question was, what is it that the student's really needing and asking for, and that you as a school believe would be appropriate for that student? Can you find ways to provide those supports outside of the IEP process? And the parents can certainly go through the IEP process to talk about what they want and what they don't want. But what can you do outside of that process? Another thing that I said is, if it's the other way, if the parents want this student to get, we want them to get pulled out of class every single day because we want them to go to counseling every day, and the student is saying, look, I just want to go to class. I just want to focus on my schoolwork. I'm doing fine with the counseling. I don't need it. And the school is in agreement with that. Well, I'm sure we've all worked with special education students who don't always attend all of their related services. So if the student stays in class and doesn't go to his related service, maybe that's something that is you're just going to overlook if everyone's in agreement that this really is the right thing for the student to do. So you can have it on the IEP, you can provide it, you're offering it to the student's just not showing up. Maybe that's a little bit outside of your control. So I think there are ways to get creative. And certainly always, you want to follow the law, you want to uphold the rights of parents. I'm not suggesting, violating the rights of parents under IDEA. But I am suggesting keeping in mind the duties that you have under McKinney-Vento to remove barriers to enrollment and retention in school for McKinney-Vento students. So in this case, this had become so contentious that the student was really at a point of saying, I'm just not even going to come to school anymore because this is very traumatic, it's very dramatic, and it's too much for me. So now you've got a barrier to enrollment and retention. So under the McKinney-Vento Act, you have to address that. So looking at some creative solutions to address it. So let me pause for a second before we go on. We have two other topics to talk about, but I see a number of questions and answers in the chat box. So let me hop in there really quickly and just to see if I can address some of these questions. So there are some questions about students who turn 18. And in this scenario, you can see that he's going to turn 18. We don't know when, but he's 17 now. So when a student turns 18, they do have some additional rights. IDEA is a little bit tricky because, of course, IDEA covers students up until their 22nd birthday. So a student who turns 18 does have rights. The question would just be, does the student's disability make it so that the student really is not capable of exercising those rights? For most of your students, that's not going to be an issue. They are an adult and they're going to be able to exercise rights on their own. There certainly are students who have disabilities that are severe enough that they really can't, competently exercise their own rights. And so that would be an issue. But I actually am going to look into that a little bit more, and I can send out a follow-up email to you all about exactly what are the rights of parents versus youth when that youth turns 18. Because IDEA is so specific about giving rights to parents. So I'm going to check that out and just make sure I'm giving everyone the most exact and specific information about that. We have another question about how can we meet the requirement for a parent to be invited to an IEP meeting when it's not safe for the student to be in contact with the parent? So yeah, there are a couple of ways to do that. And that's a really great question. Because of course, again, remember under McKinney-Vento, you need to remove barriers to enrollment and retention in school, and you certainly don't want to put a student in an unsafe situation. So I'd say a couple of things. The student actually doesn't necessarily have the right to be in an IEP meeting. Again, IDEA gives rights to parents, not to students. So the parent does have the right to be there. The student does not. So there might be a situation where you might have a conversation with the student and say, look, your parent's going to be there. It's not safe for you to be at the meeting with your parent. How about if you don't go to the meeting, but we provide you, I can provide you with the step-by-step summary of everything that happened. I'll call you right after the meeting ends and tell you what happened. So that might be an option to just not have the student attend. If the student really wants to attend and the school feels like that's important for the student to be there, then you could look at some remote options. Maybe the student is there just listening on the phone or on a Zoom, or vice versa. Maybe the parent is on a Zoom or on the phone and the student is there physically. Under IDEA, it is specifically allowed to have virtual participation in meetings. This even predates the pandemic. So you can look at having someone participate virtually if that is safe. It may be that even just hearing the parent or being exposed that way, maybe that's not even safe. So obviously you want to keep that in mind. Certainly, if Child Protective Services is involved, you want to involve them in this as well. If there's been some kind of a restraining order against the parent, then I would say, look at involving social services to see what's safe and appropriate. Maybe it's okay for the child to be there if there is a third party from social services there as well. So maybe social services can send someone to be there kind of as a buffer, as a mediator between the parent and student. So it kind of depends on what exactly are the terms of this separation between the parent and youth. So I guess the short answer is get more information and try to determine, what is going to be safe for the youth. It may be that the youth just doesn't participate and you give the youth information after the fact, because again, it is the parent that has those rights. I do see someone contributing that the age of majority is different in each state. That's true. Most states it's 18. In some states it's older and maybe even younger. But under the federal law of IDEA, there are federal policies on that as well, and that's what I really want to check on is those federal policies. So one last question on this topic before we move on. We have a pretty good scenario here that I think we can work through. In this scenario, the person is asking, what if the student lives with and is primarily cared for by the grandparent? The district knows where the parent is living, and in this case, the parent is living in a homeless situation. They're actually living outdoors, so they don't have, a stable living environment. The parent has denied special education testing, so they have refused to consent for evaluations under special education. The parent has a fear that somehow special education testing is going to connect to her Social Security income and the SSI that perhaps she's getting for the child, even though the child's not living with the parent. We've all seen this before. The parent is getting some kind of Social Security income for the child. So the parent's afraid that somehow, which by the way, this doesn't happen, but this is the parent's fear that somehow special education testing is going to make her Social Security income start to go to the grandmother. Now, the grandmother does want special education testing, and the district agrees that the student really probably could benefit from at least an evaluation, if not special education services. So we're kind of back to almost the same scenario that we have right now on your PowerPoint. In this case, it's not the student disagreeing with the parent, it's the grandparent who is disagreeing with the parent. There's not much that you can do here. Again, if the parent is specifically not consenting to evaluations, you don't want to do evaluations without the parent's consent. That would be a violation of IDEA. So, you can do a few things. You can try to address the parent's fear. So, for example, there would absolutely be no reason, and in fact, it would be illegal to require the parent or the child to provide a Social Security number to the school. So maybe you can tell the parent, look, we don't have your Social Security number. We don't have the child's Social Security number. We're not going to ask for those numbers. And so there's no way that this could ever be connected to Social Security income, because that would have to be done through the Social Security number. So maybe you can try to provide some objective facts to help the parent feel comfortable that, this really is not related to your Social Security income. Try to convince the parent that way to go ahead and get the evaluations. If you can't do that, again, maybe there are supports that can be put in place outside of the special education process. So you can provide services that are very similar to what might be in an IEP without actually going through the IEP process. And then a last resort would be actually a dispute, a formal mediation or dispute under IDEA with the parent because the school really feels like evaluations are necessary. And so the school is going to actually file a dispute on that. So hopefully that cleared up a little bit of your questions there. I'm going to go on to the next topic area now, and we'll come back to more questions in a few minutes. So the next topic area is about that timeliness of evaluations and services. So one of our students has an IEP from their previous school district. So, they were in school somewhere else this year, and, maybe yesterday they just showed up in our district because they moved. They have that IEP from the previous district. We're trying to enroll them immediately in our school, but the special education team is saying a few different things. They're saying they can't start school until we get a copy of their current IEP. They can't start school until we complete a new IEP in our district. And they can go ahead and start school, but they're not going to get any services until we complete a new IEP in our district. So what is the correct process for the student? We are lucky because IDEA actually lays this out quite clearly. So first thing, if a student has a current IEP from this school year, or even if it was finished last year, but it was for the current school year, a 22-23 IEP, then the new local educational agency, so school district or charter school, must immediately provide appropriate services. If you've been working on McKinney-Vento for a while, you're gonna recognize that word immediate from McKinney-Vento, right? But this is actually not McKinney-Vento, this is IDEA, again, using that word immediate. So the new school district or charter school must immediately provide appropriate services. So that does not mean, if we see here on the previous slide, that third bullet, they can start school, but they're not going to get anything. It does not mean that. It also doesn't mean the first bullet, they can't start school until we get a copy of their IEP or until we complete a new IEP. So what does it mean? Well, appropriate means services comparable to those described in the current IEP. So why does it say services comparable? Well, you might get an IEP from a previous district that has some services on it that you and your district really are not prepared to deliver. So the classic example is, a student gets some kind of a physical therapy service in a pool, and the school had a pool. Their previous school had a pool. So they would go to the pool once a week. They do their physical therapy in the pool. They come to your district and you don't have a pool. So clearly you are not going to install a pool for the student. You're going to provide comparable physical therapy that is not in a pool. So that's what we're looking at. We're looking at what is the service, what is the need the service is meant to address, and what's a comparable way for us to address that same need. If you can do everything that's in the IEP, then do it. Fantastic, do everything. But if you can't do a particular thing for a very specific reason, then you want to provide comparable services. Then you're going to consult with the parents on that. So again, you can tell the parents, hey, you know what, we don't have a pool, but here's how we're going to do physical therapy. What do you think about that? Because again, parents have rights under IDEA. So you've got to provide those services. You've got to get the child's records from the previous school, and this previous school must respond to those records requests. Again, if you work in McKinney-Vento world, that language sounds really familiar to you, but again, this is actually from IDEA. So even under IDEA, the district has to, or the school has to get the records, and the previous school, regardless of fines or fees or whatever other thing that might be causing a delay, they have to release those records right away. So if you don't have the records, if it takes a day or two or whatever to get the records, you still have to enroll the student. You still have to provide services immediately. You can ask the student or the parent, hey, do you remember anything about your previous program? Maybe the student might say, oh yeah, I got pulled out, once a week to go see Miss Julian L. And then you can do that old fashioned thing where you pick up a phone and you call the previous school and say, hey, who's Miss Julian L and what was she providing? And then you can put that in place, while you're waiting to get those records, which again, hopefully you will get those records immediately. So the students in school, the student is getting services comparable to those in their IEP. And now we can figure out, what are we going to do with the paperwork? So again, this sounds very McKinney-Vento-like. Student is in school, student is getting services. And now we can figure out, does the new school district want to just go ahead and adopt the old IEP? So basically just have a meeting with the parent, kind of get to know the parent and sign off essentially on what's already there. Or do they want to make some adjustments to that IEP and develop their own? Again, they're going to do that obviously with the parents, and they can go through that process, and that's perfectly fine. But the point is, in the meantime, the student is in school and getting services. And again, in McKinney-Vento world, we have very similar language, right? Immediate enrollment without school records. Enrollment does mean actually attending classes and participating fully in school. It means without delay. So McKinney-Vento and IDEA are walking hand in hand on this. We're all in agreement on what has to happen for the student. Now, a related scenario is a student does not have an IEP yet, but we have a student who is in the middle of the process of being evaluated for special education services. So they were referred for an evaluation, maybe they were a couple of weeks into that process, and then they changed schools. So we went ahead and enrolled him in the local school. And this was a question we got from a service provider, actually, not from a school district. So the service provider is saying the school says they need to start the evaluation process all over again from the beginning because it's a new school district. They can't use what was done in the previous district. They need to start from the beginning. And they're also saying he can't start school until the evaluation process is complete. So hopefully the previous slides already told you that that second bullet is not correct. Obviously, under McKinney-Vento and IDEA, we've got to go ahead and get the student in school. You don't keep a student out of school while you're doing evaluations. So we're going to get the student into school, but what are we going to do with this evaluation process? And again, we're lucky because IDEA is really clear on this one. So what IDEA says is that once evaluations begin in any school district or charter school, the clock doesn't ever stop running. The clock continues to run when a student changes local educational agencies. So if they started their evaluations in October in McKinney School District, and now it's December and they're in Vento School District, you don't start the clock over again in December. It's still running from October. Time frames for completing evaluations are a little bit different from state to state. It might be 30 days, it might be 45 days, it might be 60, it might be 90. So that can be different in your state. But the point is, let's say, for example, it's 60 days and this started on October 15th. December 15th would have been the deadline to have this process completed. It's December 1st today. You've got 2 weeks. You do not have 60 days. That is going to be true unless the new school district or charter school is making sufficient progress to ensure a prompt completion of evaluations and the parent and the LEA agree to a specific timeline for completion. So again, if this student comes into you today, you've got 14 days. That's not a lot of time. That's not even 14 school days. So you want to obviously get those records immediately from the previous school district. You can see in the second bullet there, you do have to coordinate as necessary and as expeditiously as possible to ensure prompt completion of full evaluation. So the first thing you want to do is get everything the previous school district has done, all the reports, all the documentation, talk with the school psychologist, see what's done so that you're not redoing things that have already been done. You know, the other district might have been basically done and they were just waiting to sit down and have a meeting. So now you can say to the parent, okay, cool, we've got 2 weeks, no problem. We'll set up a meeting next week. We're going to finish within the original 60-day time period. So that's great. You might find out that maybe the previous district was a little slow and they didn't get much done and you have a lot to do and you're not going to be able to do it in 14 days. That's when you sit down with the parent, have a conversation about the time that you need to get it done. And as long as you're making sufficient progress to ensure a prompt completion of evaluations, you're okay. So in other words, if your proposal to the parent is, let's start over at day 1 and give us the full 60 days, that's not sufficient progress to ensure a prompt completion of evaluations. Your proposal needs to say, well, the last school district completed A and B, we need to complete C, D, and E. It's going to take us 3 weeks to complete C, D, and E, and then we're going to have a meeting with you. So we're probably looking at about 25 days. How about that? Can we do that? It's going to be done before, we're going to make sure it's done before winter break, for example. Or we're going to have our meeting with you first week of January. You know, it has to be, again, prompt. I've worked with students who have moved around so many times. I remember once I had a young child, 5-year-old with autism, who had moved around so many times that he had been trying to get evaluations done since he was 3 and had never gotten them done. So he had never had an IEP. because they kept starting over and over and over every time he changed schools. That is not the way legally it needs to be. And by the way, these provisions under IDEA, they're not even specific for McKinney-Vento students. This is for any student who's changing schools or school districts or charter schools in the middle of the year. So it certainly would apply to McKinney-Vento students, but it also applies to any highly mobile student. So just so you know that. And again, remember, as I mentioned this before, the McKinney-Vento Act does require us to remove barriers to identification, enrollment, and retention. And so all of these provisions under IDEA really are related to this. If you have a student who needs special education and related services and they're not getting them because of delays in the process, that's a barrier to enrollment and retention. And so again, we have these two laws really working hand in hand. Okay, let me do another scenario here. And then before we start to talk about transportation and school of origin issues, I'll take some more questions. So if you have any questions that you want to pop in to the Q&A box, please go ahead and do that. In the meantime, I want to do this one last scenario because this is something I hear a lot too. We're getting resistance to doing special education evaluations for some of our McKinney-Vento students who have changed schools frequently or have missed a lot of school, as well as for new students who are receiving RTI services. RTI, in case you don't know, stands for Response to Intervention. And these are interventions that are not special education, but they're other kinds of supports, behavioral supports or other supports for students. Again, and this is not special education yet. It may lead to that eventually, but it is not special education. And so sometimes I've gotten questions from schools where, you know, a school psychologist has said, well, this student has missed too much school. They haven't been in school enough. And so we can't evaluate them for special education because maybe they're having trouble in school just because they've missed so much. Or, well, let's get through this RTI process first. We've got a 3-month RTI process that we're going to work on. Let's see how they do with that. And then we'll do special education evaluations after that process. So what are the rules about evaluating students in these situations? And again, we've got some pretty clear rules here. So obviously, it may be the case that a student might be struggling in school because they haven't come to school a lot. You know, that makes sense. And we don't want to give a student an IEP and say that they have a disability and they need special education if that's not really the case. So of course, we want to be sensitive to issues like attendance in school and other issues. So IDEA is very clear that you cannot find a student eligible for special education if the determinant factor is lack of instruction in reading or math. So basically attendance. You know, if they're struggling in reading and math because they haven't been to school enough and it's really not related to a disability, then we don't want to put that student into school. We can't put that student in special education. So that makes sense to me. However, how can you know if this is a disability or if it's a lack of attendance if you don't do some testing, right? So IDEA also is clear that these issues must be considered upon completion of assessments and other evaluation measures. So this does not mean, well, let's wait until Patricia is in school for 30 days in a row, and then if she's still struggling, then we'll go ahead and do evaluations. That's not what this means. What this means is if a parent has requested evaluations, we need to do those evaluations, and we're going to go through the process. And then when we sit down and have our meeting to determine, does Patricia need special education, we're going to look at her attendance and we're going to look at the evaluations and we're going to make a determination about whether special education is a need or not. Because your evaluations are going to show certain aspects of that child's learning abilities and perhaps emotional needs that go far beyond attendance or non-attendance. You know, so your special education team is going to be able to look at all the information and put 2 and 2 together and make a determination about eligibility. So this is something I hear a lot, but if you do hear this, you know, we can't do evaluations until they come to school more. That's incorrect. If a parent has requested evaluations, those must be begun. Those must be commenced, and you go through it and then you figure it out. The other thing is, if the district is providing RTI, like I said, response to intervention or a multi-tiered system to support or other supports for students, that's great. And you know, absolutely, you should continue doing that. But again, you cannot delay completion of special education evaluations because of an MTSS or RTI process. So again, we can do both of these things at the same time. You can put those supports and interventions in place and also do a special education evaluation at the same time. Sometimes a parent might agree and say, you know what, well, let's wait. Let's see how this intervention goes, and we'll check back in a few months and see if we want to do an evaluation. And that's fine. I think the issue for our McKinney-Vento students and really all of our highly mobile students, again, is if students are changing schools a lot and they're moving around a lot, well, then you start ITI in one district, and then you go to another district, you start RTI again in the next district, and then you start it again in another district, and you can have a whole school year or two or multiple school years go by where you're still trying interventions, and you never actually get to the question of, does the student need special education? And so that's why the law is clear and the Department of Education has been clear that we don't want to delay. Well, we cannot delay evaluations for these reasons. So Department of Education actually came out with a letter on this back in 2013, but then just about 3 weeks ago, they issued another letter updating all of this information. So the link to that letter is on your slide here. It's pretty hot off the presses. And you can provide that, if you're having any questions with your special education team, you can provide that to them. It might not have filtered down to the local level yet because it just went out to states a few weeks ago. So you can provide that to your local team and just make sure they're aware. They're also within that letter, there is a link to the 2013 letter, the original letter that came out on this as well, way back in 2013. So you can get that that legal backup that somebody put in our poll earlier today. Okay, so before I get to school of origin and transportation and out of district problems, I'm going to hop back into the chat box, the questions box again, and see what we can say. Okay, we have a question here that looks like it's a pretty complicated one about students with an IEP regarding post-secondary transition. The U.S. Department of Ed Post-Secondary Transition Guide indicates that students must be invited to an IEP meeting where post-secondary goals are being discussed. So that's an important provision that I was not aware of, and so I appreciate you bringing that to my attention. What I'm going to do is I'm actually going to copy the link that the questioner provided, and I'm going to put it in the chat so that everyone can see it. Let me do this very quickly. Because this is important information and I appreciate you sharing it. The person is actually anonymous. So thank you, anonymous, for sharing that information because that's really important. I don't ever want to diminish youth rights. Youth rights are really important to me. So I appreciate you clarifying this particular case where youth do have the right to be at that IEP meeting. So thank you very much for sharing that. And I learned something today. So I appreciate that very much. Okay, I think that I don't see any more questions in the Q&A right now. So let me go ahead and continue, and we will have, again, more time for Q&A after the next couple of slides. So we're going to get into the sticky issues now of out-of-district placements and transportation and who pays and all that good stuff. So scenario 6. This happens pretty frequently that a McKinney-Vento student or any student with an IEP will be placed outside of their school or their district. So they might be placed in a public school or a private school because they have needs that their local school can't meet. And so their local school will go ahead and send that student to a school, whether it's a public school or a private school, that can meet those special education needs. So when a McKinney-Vento student with an IEP is placed in a public or private program that is not physically located in that building of their school or district of origin, do they have the rights to continue in that program the following school year if they return as a McKinney-Vento student? So it's the school of origin question, basically. And do they have the right to transportation to that school? So let's remind ourselves about what the rules are under McKinney-Vento. So under McKinney-Vento, students have the right to remain in the school of origin according to their best interest for the duration of homelessness and until the end of the academic year in which the student becomes permanently housed. They also can enroll in the local school. Again, this is based on their best interest, but there is a presumption in favor of the school of origin, as well as a priority to parent and unaccompanied youth wishes. So in this scenario, if we assume that the parent wants the child to continue in that same school, whether it's a public or private school, the child was placed in that school by the school district. So again, school district saying, we can't meet this IEP, so we're going to place the student in this other school that can implement the IEP. Everybody wants the child to stay in that school of origin. So the question really would just be, is it in the child's best interest? The Department of Education and actually the law, the text of the McKinney-Vento Act is clear that specialized instruction, such as special education and related services, are one of the factors that you need to consider when we're considering school placement decisions. And for special education students, most of the time, school stability absolutely is going to be best for them. The upheaval of changing to a new school with new teachers and a new routine, for the most part, is not going to be in the child's best interest. So probably we are going to want to keep that child stable. It doesn't matter that the placement is not in the building of that school of origin, because that building is not where the child is attending at the moment, right? And remember, the school of origin is the school the child attended when permanently housed, or the school in which last enrolled. And enrolled means attending classes and participating fully in school activities. So where's the student attending? Well, they're attending at that other school. Again, whether it be private or public or wherever the school district sent them, that's where the student is attending. That's their school of origin. And so they do have the right to stay there if that's in their best interest. So I don't think that this is a particularly controversial or problematic issue. I think the issue really gets to transportation. Who's going to pay and who's going to arrange for the transportation for the student to get to and from that school. And we're basically going to follow what McKinney-Vento says. McKinney-Vento says that we have to provide students in homeless situations with transportation to the school of origin. Just because this is a special education placement, that doesn't change that rule. If the student is crossing LEA lines or school district boundaries, then the school district where the child is attending and the school district where the child is living would have to share responsibility. So in this case, we're really going to look at what is the school that made the decision that said, this is where the child's going to attend? What's the school who wrote that IEP and made that placement? That school is going to have to be responsible for transportation. If the student is living in another district, then those two districts would agree on how to share responsibility and costs, and they can come to any agreement they want. And if they can't agree, they split it 50-50. So just like regular McKinney-Vento transportation. The only trick here is sometimes transportation is listed as a related service on a student's IEP. So sometimes it is, sometimes it isn't. It isn't just listed because a student needs a way to get to school. It's listed on an IEP because that student has some special needs that really require transportation, or perhaps require some special services on transportation, like maybe they need a special kind of seat, or maybe they need an aid on the bus, or transportation is really only going to be on an IEP if it is somehow related to the student's disability. Now, I used to work as a special education attorney, and I got transportation on all of my clients' IEPs because I just thought it was important, and we fought for it and we did it. But that's not typical. So you can't assume that a student has transportation on their IEP. You really have to look at it. You have to ask your special education team, hey, is transportation on the student's IEP or not? If it is, then special education needs to be in charge of arranging that transportation and paying for it. So that's just a question for you to ask. If it is on the IEP, then special education is going to take care of transportation. If it is not on the IEP, then you're just going to follow your typical McKinney-Vento rules for transportation. And that's really what it comes down to, is just taking a look at that IEP. So the last issue I wanted to talk about is our young children, those who are under 5, because sometimes I would say more than sometimes, I would say very, very often, our McKinney-Vento families include children who are under age 5 and who appear to need have some special needs. So what do we do for children under 5? Well, preschool special education is special education services for children age 3 and above. And those services are covered by everything that I've been talking about in IDEA. So the idea around completing evaluations in a timely manner, completing assessments, completing IEPs in a timely manner. What do you do when children change schools or school districts? The ability to stay, the right, I would say, to stay in the school of origin, the right to have transportation to the school of origin. All that applies just equally to your preschool special education students who are 3 and above. The McKinney-Vento Act also applies. If a preschool is not a school district program, if it's like a community program, then McKinney-Vento wouldn't apply. But preschool special education is always a school district program. So McKinney-Vento always applies to preschool special education. So all the rules that I've been flipping through throughout this entire PowerPoint will apply to your children age 3 and above in preschool special ed, just as it would apply to anyone of any age. Even the surrogate parent pieces that I talked about. If you have a 3-year-old who's living with grandma, and maybe parent is around, maybe parent isn't around, you're going to go through those same unaccompanied youth procedures that I mentioned at the very beginning to figure out who has the right to make those decisions for that child. So 3 and above is all the same. Once you get below age 3, things get a little bit different because now we're actually under a different part of IDEA. It's IDEA Part C, if you want to know the part legally, what it's called. And it's early intervention. And these programs sometimes are provided by school districts, but oftentimes they are not. They are provided by community agencies, mental health agencies, or other organizations that are outside of your public school system. So for infants and toddlers younger than age 3, those young children who have a disability, a developmental delay, or a physical or mental condition likely to produce a developmental delay are going to be eligible for these early intervention services. In many states, they also include at-risk infants and toddlers, so those who might be at risk of a developmental delay will be covered. And it's similar to your school-based services in that children will get something called an IFSP, an individualized family service plan, instead of an IEP, which is an individualized education program. The great thing about IFSPs is they are for the family. So they're really going to be looking at the needs of the parents or the caregivers, as well as the needs of the young children. Oftentimes there are social work services that can support the family to do things like find housing, find a job, find other support. So it's a program that can be tremendously helpful, not only for the infants and toddlers, but even for their older siblings, because it is supporting the whole family. So I have on the slide 2 links where you can find information about who provides early intervention services in your state. How can you connect to those programs? If you don't know your local early intervention agency, I would really encourage you to click on the link, find your state agency, and then find out who's available locally and get in touch with them and make sure they know you. They are probably working with families who are McKinney-Vento families that they could be referring to you. And I'm sure that you are probably working with families who have infants and toddlers who maybe need to be referred to early intervention. So it's a really rich opportunity for collaboration if you can find those organizations in your area. And in my experience, they're really great organizations, kind of similar to Head Start in their family-oriented approach and really looking at the whole child and the whole family. So take a look at early intervention if you hadn't. And that kind of gets us to our bonus, which is about those areas for collaboration and for working together. Every state is required to ensure that all students with disabilities, including infants and toddlers, so all children and youth with disabilities who need special education, are identified, located, and evaluated. So again, if you come from the McKinney-Vento world, that sounds pretty familiar to the requirement under McKinney-Vento to ensure that all children and youth experiencing homelessness are identified and served. So you have 2 systems that are working next to each other to identify students. And when those 2 systems work together, it can be really powerful. So I've worked in local and state organizations where I've been able to watch them do Child Find. Child Find is the special education version of finding children who need special needs, and identification is the McKinney-Vento version of identifying our McKinney-Vento students. So if you are likely to have in your school district, in your community, lots of Child Find activities going on, particularly at the beginning of the school year, fairs and opportunities where parents can find out information about special education. You can tag on to those events to also find McKinney-Vento families and students. And same thing, if you're doing activities to identify McKinney-Vento students in the community or in your school, it's an opportunity to let Child Find kind of tag on to what you're doing. So if you can find out who in your district is working on Child Find, somebody in your special education program is probably working on that, and find out what they're doing. Early intervention, again, your early intervention program definitely is doing Child Find activities. So if you find your early intervention program and say, hey, what Child Find activities are you doing? Can we provide you with a brochure? Can we provide you with wallet cards? Can we come and set up a table at your activity? It can be a great way to kind of get a twofer and be able to identify students across both programs. So with that, I am going to jump back into the Q&A pane again. Please feel free to answer any questions you have, any specific scenarios you're struggling with, or questions you have that I have not addressed, maybe some topic areas that I did not address for you. And I will be happy to try to answer your questions. So let's see what we have here so far. A student is assigned to a special unit at the school of origin, and they want to return to that school where they have McKinney-Vento rights. Can a district place them in a comparable unit in another building because of space issues, like the unit is full? So that's a really good question. When we're talking about the school of origin, space issues really cannot be a problem because that's the child's school of origin, right? That's where they are attending. They're there, they have a space. And so they need to be allowed to stay there because that is their school of origin. And if it's in their best interest, then that's where they need to stay. So to say that there's no space for them when that's their school of origin, it kind of doesn't make sense because it's already their school. It might be different if they just arrived from another district and there's a special class, but that class is capped and there's no room in that class for them. Then the district would need to do what they would do for other students. And so if that means that they're placed in a comparable unit in another building, then that would be fine. But if it's a school of origin issue, then the student does have the right to remain in the school of origin, regardless of space limitations. And the liaison absolutely can and should advocate for that because it is that child's right. Again, assuming that it's in their best interest, which it seems pretty clear from the scenario that you provided that it is. So thank you for that question. So let me pause for a minute. I'll stop and take a drink of water and see if there are any other questions that you all would like to submit. Well, I don't see any other questions coming in, which is fine. I'm very happy to give you a few minutes back in your day. Please make sure that you reach out with us with any questions that you have after the webinar. Again, there's the link to the Q&A from our inbox where you can see lots of Q&As about special education. I will follow up with you all with some more information about the rights of students who turn 18 under IDEA. It's bothering me that I didn't just have that offhand, so I'm going to look that up and get it to you. And otherwise, if you have any other questions, please feel free to reach out to us. Check out our Facebook group. If you use Facebook, it's a good opportunity to get in touch with colleagues. So you can ask questions of colleagues, share documents, share forms, kind of brainstorm with other people around the country who are working on McKinney-Vento issues. So feel free to check that out if you use Facebook and sign up for our newsletter if you like. But other than that, I just want to, again, thank you for your time. I'm really grateful for everything that you all are doing each day to support children and youth. I'm happy for the opportunity to be with you today, even though it's only virtually. And I just want to wish you all a very peaceful and happy and loving holiday season. So thank you all for being here. Bye-bye.